In this second podcast in Module 2, we're going to be looking at the requirements to obtain a divorce in Australia and just the basic steps that you would need to go through if you're a lawyer acting on behalf of a client that wants you to make a divorce application for them. We don't go into great detail about this area in this unit because I guess these days many clients make their own applications for divorce, so it is becoming a lesser part of a family lawyer's day-to-day activities. Now I guess the most important thing to realise is divorce is a totally separate application to other types of family court applications, such as making an application to the court for parenting orders or making an application to the court for property orders. It's totally separate. For example, you can make an application to the court for parenting orders or property orders immediately after separation, but you can't make an application for a divorce until the parties have been separated for 12 months. Although there are two family courts, the Family Court of Australia and the Federal Circuit Court, all divorce applications are now filed in the Federal Circuit Court of Australia, as it's the court that deals with less complex cases. An application can be filed either by a husband or wife or by both of them as a joint application. And it actually makes the application easier if they can cooperate and make a joint application. Because of the requirement for a 12-month separation, the application can't be filed in court until 1 year and 1 day after the date of separation. Now, people don't need to register their separation date anywhere. They just keep a note. Provided they both agree on it, there's no issue. Sometimes people do argue about the date of separation. I guess that won't be an issue if they're both happy to divorce and both happy to wait 12 months after the last date of separation. Sometimes it does become an issue, and then people would have to provide supporting evidence. To file an application for a divorce, you generally need the client's marriage certificate. If it's in another language, it also needs to be translated into English. If there is no marriage certificate, there needs to be some sort of evidence of the divorce, and I guess in that case we're talking about overseas marriages. When you're applying for a divorce on behalf of a client, you need to supply them with what's called the Marriage, Families and Separation brochure. Also, if you're serving documents on the other party in relation to a divorce application, you need to supply them with that brochure as well. The reason behind this is that the underlying philosophy of the Family Law Act is to keep families together wherever possible, and also provide people with information about where they could get help, for example for marriage counselling. So the brochure provides that sort of information. Now the filing fee has recently gone up. It's now $1,200, which is quite expensive. If people think that they would be entitled to a reduction in fees, they can fill out the form, and I've given you the links to all of that information and to the forms, and they may be entitled to a reduction of filing fee down to $280. Now, to file an application in an Australian court, you do need to have some sort of connection with Australia. And I've set out on that slide, say if we're filing on behalf of a client, what sort of connection they have. They might be an Australian citizen, or they might regard Australia as their permanent home. And in that case, they need a valid visa or passport. Or they might have ordinarily lived in Australia and have lived here for 12 months before filing the application, and again they need a visa or passport. Now, I guess the next step is, what do you need to show to apply for a divorce? Well, we have what we call no-fault divorce in Australia. It came in 1975 when the Family Law Act was first introduced. Prior to that, you had to prove fault to obtain a divorce. For example, that the other party had committed adultery or had deserted you, and that involved the providing of evidence to the court and became quite complicated, for example, with people having to hire private investigators to catch people in the act of adultery, which I guess certainly made being a family lawyer a bit more exciting. However, now it's much more clear-cut. What you need to show to the court is the marriage has broken down irretrievably, the husband and wife have lived separately and apart for 12 months, and there is no reasonable likelihood of cohabitation being resumed. If they have children under 18, the court must also be satisfied that proper arrangements have been made for the children of the marriage. Now, in relation to proper arrangements, if people are unable to agree on parenting arrangements after separation, that is the time the children will spend with each parent. I guess proper arrangements could be that they're negotiating about that, or that they have filed an application in court to resolve that, or that they have made a date for mediation about that. So I guess they don't need to have been finalised, but you do need to show the court that you're certainly in the process of agreeing on arrangements for the children. Now, there is an application for divorce kit that people who want to act for themselves in a divorce can now use, and they can also make a joint application in this manner. So they'll need their their marriage certificate, and they're either making a joint application, or if they're making an application by one party, they then have to serve the divorce documents on the other party. Now, service just really means providing a copy of the divorce application and other relevant documents to the other party in sufficient time before the hearing. And I've got the time limits there up on that slide. You can either serve a divorce application personally, so say the person making the application could serve or hand the documents to the other party, or you could get what we call a process server, someone who does that as a job. Then there has to be another form evidencing that service. So you can see that I guess once you're familiar with the process, it's fairly straightforward. Have a look too in relation to service at the DVD on the YouTube playlist, which explains about service, because I guess if it's a sole application, that is a key thing that you have to show the court, that you've given the other party sufficient notice of the application. Now, often in practice, the other party will get that notice and they may not do anything. You'll have the proof that they've been served, but they don't actually come to court. However, they are quite welcome to do so. Just the fact that they don't come to court doesn't mean that the application can't go through. Now, in some cases, particularly these days when housing costs are so high, sometimes people do separate, but they remain living in the same home, and in law we call this separated under the one roof. Now, to make an application where you've been separated under the one roof, you normally have to provide some independent evidence to establish that you have been separated under the one roof. And I guess in technical terms, to show that the consortium vitae has broken down. And you can have a look in the textbook at the discussion of the marriage of Pavey case about separation under the one roof. Normally, the sort of person you might get to corroborate is if you've got an adult child living in the house, a neighbour or a close friend. And I guess what you're trying to establish to the court is, although you are living under the one roof, You are no longer acting as if you were married, and that the essential requirements or elements of marriage weren't present there. And for example, the types of evidence people might provide is that they were sleeping in separate beds, they weren't going out as a couple together, they weren't cooking for each other or doing domestic tasks for each other. And really it's just a matter of the particular facts in that particular case, what sort of elements were present in that marriage prior to separation, and then whether they were not present once the people are saying they separated. Now, because the Family Law Act does encourage people to reconcile, there is this provision in Section 50 of the Family Law Act that people can be separated for 12 months by adding together 2 periods of separation, even though they might have had a period in the middle of reconciliation of up to 3 months. So say, for example, they may have been separated for 6 months, got back together for a month, it didn't work out, and then they were separated again for 6 months. Under this section, you can add together the 2 periods of separation. Now, there are special requirements if you've got a client who hasn't been married for 2 years and they want to divorce. And I guess the reasoning behind this is, again, to be totally sure that the marriage cannot work. So there is a requirement that people have to attend counselling prior to applying for their divorce, and they need a certificate from the counsellor. Now, I guess ideally both parties should attend. However, in practice sometimes the other party chooses not to attend, and the fact that your client has gone along and obtained the certificate will be enough. Now, previously divorce was called a dissolution of marriage. It's now called when a divorce order, and the legal term is when a divorce order takes effect. So something to understand is that when you file a divorce, you'll get an application for a hearing date. So if it's a sole application, you'll then serve the documents, file the document proving service, and then you'll go along on the actual hearing date to actually make a formal application to the court in oral terms for the divorce. Something important to understand, though, is that if the court grants the divorce on that day, it doesn't become effective until 1 month from the date of the actual day of the hearing or the day of the order. And again, that's in case people have second thoughts and they want to go back to the court and ask for that divorce order to be set aside. Something that sometimes happens in practice if you're working as a family lawyer is that you might have a client who's only divorcing because they want to remarry. Sometimes people wait many years after separation to divorce. Sometimes people never divorce because of, I guess, the effort required in organising it, and also now the costs of the filing fee. Something they need to be aware of is that you do need to give at least 1 month's notice of intention to marry. So you do have to be careful to let them know that the divorce won't be final until a month after the hearing date. Then it's only then that they can give their notice of intention to marry. So they have to be careful that they don't set up their wedding without leaving enough time for all of that. Another very important time limit is that for people that are married, an application for property settlement must be filed within 12 months of the date the divorce order came into effect. Now, that's a very important time limit, and sometimes lawyers in practice get caught out. If you don't file your application for property settlement within that time frame, you can apply for leave to apply out of time, but it will only be granted in circumstances such as if your client will show that they will undergo hardship either to themselves or to themselves and a child of the marriage. So it's very important that lawyers have in place some sort of system to keep track of these time limits, and that they also advise clients up front of the time limits as well. Now, something I didn't touch on in the last podcast is that, and I think I talked about same-sex marriages entered into overseas not being valid at the moment in Australian law, and you can't register them in Australian law. Similarly, I just wanted to point out that a marriage in accordance with traditional Aboriginal customary law is also not a valid marriage in Australian law and is not recognised. So just something, I guess, interesting to note. Now, a good text in this area, if you do go into practice, is the Marie Livermore Family Law Handbook. So if you do end up working in this area, I'd certainly get a copy of that handbook. If your workplace doesn't have one, it's got really practical information. It's actually designed for clients, but very good for lawyers as well, particularly if you're starting out in this field. And if clients have been separated under the one roof, I said that they would have to supply supporting evidence to the court. Now, the way that they would do that is they would need to get an affidavit, which is a sworn statement by either an adult child, neighbour or close friend, to really support their contention that they were separated under the one roof. This sworn statement then gets filed in court and served on the other party. Now, that's all for that podcast. The next podcast in this module will be in relation to the family.